The purpose of these videos is to assist an information officer and the relevant authority when an internal appeal comes before them. Once an information officer or the relevant authority receives an internal appeal, then they have a duty to respond to that. If the relevant authority fails to respond to the internal appeal that is before them, then in terms of Section 77 of PAIA, that PAIA request is essentially deemed as having been dismissed. This means that all the internal remedies have been exhausted, and the only options that are left available to the requester is to either approach a higher court for remedy or to make a complaint to a Chapter 9 institute or the information regulator. But once the relevant authority receives an internal appeal, then they have the duty to take a decision. And the decision that can be taken will be either to confirm the decision that was taken by the initial information officer or to substitute that decision with a new one. It is important to remember that the relevant authority has 30 days from the date at which they receive the internal appeal in which to make that decision. Now, if the PAIA request is either granted or refused, then the relevant authority has a duty in both instances to provide reasons for the decision and the sections of which they relied on in terms of PAIA, as well as note the relevant provisions of Section 28 and Section 46 that would apply. And it is also important that they make a note to inform the affected parties of their right to judicial review. If the decision has been made, then within 30 days, all parties must receive that decision, and that the relevant authority and all the reasons that he has made will be sent to the relevant parties. And if there's a third party that is involved, then that third party has the option to dispute any decision that they make that they disagree with. This means that if there is any dispute from the third party, then the information may not be released within 180 days or before any litigation is completed. Once a decision has been made and all parties have been notified of that decision, if the requester or the third party are aggrieved, then litigation will institute. Firstly, in order for litigation to begin, a notice of motion has to be served on the parties. This signals to all the parties that there is an ongoing case and that it is now up to the courts to decide how the PAIA request will be handled. Now, as an information officer, the duty there is to review and update the file and ensure that everything is up to date and that the court will be able to look at those records and see clearly what happened on that file. Then there's also the option to consider all the options that are before you, either settle or litigate. There's also the duty to brief the seniors and or lawyers to ensure that everybody is on board with what is happening with the litigation. And importantly, to diarize and follow up on all the timelines. These timelines are important because it includes the date in which the hearing will be made, but also any relevant dates that refer to any decision that the court takes. If the aggrieved party opts to not go to the courts, but instead approaches a relevant authority in terms of PAIA, then the information officer and the relevant authority will receive a notice of complaint which can be lodged with a Chapter 9 institute, which is either the South African Human Rights Commission or the Public Protector, as well as the information regulator. It is important to note that the information regulator, in terms of PAIA and POPI, is the relevant authority that has the right to deal with complaints in terms of PAIA. However, as of September 2018, the information regulator is not yet fully operational, but once it does, all complaints should be addressed to the information regulator. But once you receive a complaint, then the following things must be done. The information officer must acknowledge that they've received this complaint, and they must react and respond to the allegations that are placed in the complaint. The office also has a duty to participate in any dispute resolution mechanisms that will happen. And in order to do that, remember to prepare communication on the records that have been received in terms of the PAIA application, to make clear and concise logical explanations of any reasons that were given for refusing to grant the request, and to come together and make any plausible solutions. At this point, you can always refer to Section 28 of PAIA and see what mediation and how you can meet each other halfway with the requester. It is also important to note once again to diarize all the dates that are relevant to this complaint and to follow up on any agreed solution. it would be unfortunate to go all the way through mediation and for the records to still not be released afterwards, forcing a requester to then eventually approach a higher court. Once all the processes and mechanisms relating to an appeal are complete, it is the duty of the relevant authority and the information officer to ensure that they are clear with what they are meant to do and to fulfill all the obligations in terms of PAIA and all other relevant legislation. If there is any confusion and an information officer or relevant authority is unsure of what their duties and responsibilities are, they can always go into our website, in the FOIP website under resources, and look at all the specific information that we have set aside to assist municipal managers and information officers to have a clear understanding of how they're able to fulfill and complete their constitutional mandate to ensuring that South Africa lives in a more open and transparent democratic society.